But if you are, and if you're a foreign national, you usually don't have all your ducks in Mexico. You have them elsewhere, and you have your living trust and your living will in the U.S. Keep it there. Don't toy with it. But whatever you have in Mexico, and the most relevant part of your state happens to be the home, and you do have the fideicomiso, you already have state planning.
Because I know that you also can handle estate planning, right? And for people. Do you mind if we ask some questions regarding the estate planning? I think that there's a lot of confusion and we get a lot of questions about this, and we want to talk about a complicated situation. And if you don't have the answers to the questions, all of them, that's fine. But I think you could probably help clear up some confusion, because people don't understand how important it is, I think, when they come down here, especially when I want to say foreigners, when they're coming down here, to have a good estate plan. And you provide these services too. So if somebody is coming down here and buying property, once again, I'm recommending that they talk to you and get a good estate plan together for what they're doing, so that way their will, their directive, whatever it is that they're wanting to do is able to be carried out. And some of the questions I want to ask you this morning is going to be, and I got a list, and I'm going to go down from the top to the bottom and ask you, what happens in this scenario? So, Louis, what's the first question?
So the first question is, what is the process of getting a will in Mexico? And is it expensive and complicated?
Well, the process is simple. You go to a notario, and the notario will ask you for a proof of identity, being that probably a passport, stating your national origin. He will want to know about your status. Probably you have nothing more than a 180-day tourist card, or you have legal status, meaning temporary or permanent visa. Whatever the scenario is, once the notario identifies the individual, the notario will ask that the person brings from 2 to 3 witnesses that known you for a while, that can vouch to the fact that you're healthy, that you're making decisions without intimidation or without being affected by a narcotic or a disease that affects your judgment, right? So they're there to say, I know him, he's fine, he just wants to deal with end-of-life situations, and we're here to vouch for that, okay? So he has you bring those 3 witnesses. If the person giving the will is not, in Espanol we say, tenga el dominio la lengua española, which means this person is not bilingual. He will be asked to bring an interpreter. Normally the notario has an interpreter. Sometimes notarios ask that the interpreter be a certified interpreter with the state of Baja California. And regardless of whatever the decision is, there will always be an interpreter. So the notario will ask, okay, what is it that you want to put into the will? If it is a property, and that's all the person has, and most of us have cars, all of us have heirlooms, family, old coffee maker, or something that is worth something, but it's basically items, not fixed assets such as a home. I always suggest that, stick with the fideicomiso. If you do have a fideicomiso as a foreign individual, it's just a matter of reviewing the way that the property would be passed on to your beneficiaries, say husband and wife. Husband and wife must name each other as their own respective beneficiaries in the event of the other's death, so that the surviving spouse receives the portion that the deceased left, right? And there's always an alternate beneficiaries, which are normally the children or family or a charity, okay? But you have to understand that in itself in a fideicomiso is estate planning, right? And I always suggest that if you have a fideicomiso, not to worry about a will, because the most relevant asset that you have is actually your home, right? Unless you have complications such as being hugely wealthy. But if you are, and if you're a foreign national, you usually don't have all your ducks in Mexico. You have them elsewhere, and you have your your living trust and your living will in the U.S. Keep it there. Don't toy with it. But whatever you have in Mexico and the most relevant part of your state happens to be the home, and you do have the fideicomiso, you already have state planning. So what about the will? Should I have a will or not? Well, I would not include the home in the will because you already listed in the fideicomiso, right? But whatever you want to leave, such as a car or art or tables, chairs, fixtures, that you include in the will.
Can you include bank accounts in your will?
You can, yes. What is the most common description or instruction, should we say? I had one daughter, and I'm leaving Michelle as my universal heir, and she will receive my estate, nothing else. When there's more than one beneficiary, such as a widow or ex-wives or children with the same spouse or not, that I guess it becomes complicated. That's where you need the support of the notario in order to do the right thing and be able to have clear instructions without allowing this or trying to avoid this going to litigation, because there's a misinterpretation, there's fighting between siblings, or there's more than one a marriage in the past of the individual. So yeah, in those cases, you definitely have to have a will. But as I said, it depends on this complications or the state, how wealthy or how complicated the state is. And again, all the financials that people have back home, Canada, the States, what a living will, what a living trust in the U.S., that has already been taken care of. Unless you're a permanent resident of Mexico and you have everything in Mexico, okay, yeah. So keep the fideicomiso, don't put the property in the will. And you would ask, why not? Isn't the will protection? No, it is protection, but you already have estate planning in the fideicomiso. What happens if I have a will and put a property there, or if I have a fideicomiso, someone has a fideicomiso and name someone the beneficiary? When I die as a Mexican and left the will, the person who's the beneficiary will have to file for probate, go to court, get an attorney, spend $12,000 or more. Some attorneys even charge a percentage of the worth of the state in order to take care of the case. That is criminal, but that's the practice. Guess why many attorneys get rich? Because they do that, and people that love it. So anyways, when you have a will, regardless of the fact that there's a will and there's someone named as the beneficiary, it has to go to court. It has to go to probate. But if you have this other person which left the home in a trust and there's someone named there as a beneficiary, that person does not need to file for probate, doesn't need an attorney. They only need to notify the bank that the beneficiary of the trust passed away, and based on the instructions, I'm asking you to update the fideicomiso and have me as a sole or surviving owner of the property. So yeah, there's a wide difference. That's why I insist that the fideicomiso could provide all the protection you need, but if there's complexity such as I said, bank accounts, investments, insurance, even pets. I help people that have pets that actually name and left $30,000 for a pet. Yes, because that's the way they want it to be protected. So yes, depending on the person's needs and the obligations or the number of beneficiaries, it might just end up having to have a will. But if you have a fideicomiso, don't include the household in the fideicomiso in the will. It will have you burdened by having to file probate, because now you complicated to the point that you need to have the attorney. So fideicomiso, have property there. If you have a will, put all the belongings, the cars, whatever, into that will. How expensive it is, 2,400 pesos, the maximum. The notarios during the month of September charge 50% all over Baja, pretty much the whole 32 states, actually. I've seen it elsewhere as well. But in Baja California, during this month of September is the month of the will, el mes del testamento, has 50%. So it usually is around 2,400 pesos, all inclusive. When you give the will, the notario records it with the state, and it's, well, we call it Dirección General de Notarías. But everything, all inclusive, 2,400 pesos, it takes about a week. And it takes sometimes, depending on the notario, as much as 7 hours.
And how
Why?
difficult,
Because you're husband and wife. Yes.
How difficult is it to change the term of a will?
Not complicated, because, you just ask the notary to meet with you. You tell them, I'm changing the terms, I'm changing my beneficiaries, and what else are you doing? Well, that's all that I'm doing. Depending on how the notario perceives this, or the age or the health of the individual, the notario may ask for the witnesses to come back or not. That is revocable. You can change the terms of your will at any time, as long as you're capable of making decisions on your own. Now, those decisions could be made by someone else if and when there's something else besides the will. We call that a medical power of attorney, and you might call it, they call it advanced planning. No, you call that advanced directives. You can call that legal guardianship, or even what I call this in California, a durable power of attorney, which is quite different and very complicated. But in a nutshell, when most of us will eventually get to the point that we will be unable to make decisions on our own. So a husband and wife will do themselves a great favor into their children by naming each other their own respective legal guardians, by appearing in the presence of a notario, so that they name each other as their own legal guardian, if and when a situation happens where the person is temporarily or permanently unable to take care of himself or herself or make those decisions. So this is quite important. I believe that everyone needs a legal guardian or medical power of attorney compared to a will. A lot of people don't need a will, but everyone does need a medical power of attorney or legal guardianship, because at the end of the day, it all boils down to the same thing. Someone has power of attorney over you. The only difference is, keep in mind, all powers of attorney given at the time that the person who gave this dies, the power of attorney ceases to be valid. The difference with the medical power of attorney is that the medical power of attorney subsists. It is still valid even after the death of the person who gave it, particularly so when there's unpaid bills to clinics, to hospitals, or there's funds run out and there's debt, and then the person who has the power of attorney will have power of attorney to dispose of assets, to sell property, by justifying to a court and to a judge that there's debt and the state is responsible, so they have to get liquidity and put this on the market. So there's protections there. But
so is there a probate here? Like, is there a probate court like there is in the U.S.? Is it a similar process than the U.S.?
I'm not aware of how it works in the U.S. I just know that there's no probate court in Mexico. It's just what we call juzgados familiares, which is domestic law, generically. They take care of adoptions, of tutorship, state, or when you name your someone's your tutor. But yeah, in this case, it's civil. Civil courts deal with contracts and litigation. Domestic law or juzgados familiares handle what we're talking, probate and adoptions and all that. Family law.
I got a question about the will. So what if somebody there's a foreigner and they have a will in the U.S. and they have a will in Mexico? Is the will, or maybe they don't have a will in Mexico and they have a will in the U.S. Was a U.S. will enforceable in Mexico, or a Mexico will enforceable in the U.S., or vice versa, or what happens?
Well, I can tell you that at least wills given in a different country, Canada or the U.S., they are binding in Mexico, considered that the stipulations and instructions given by the grantor do not violate Mexican law. Give you an example. I've seen cases, and I participated in living wills in the U.S. and living trusts in the U.S. I haven't done that because I'm not licensed, but I've been working in tandem with colleagues in the U.S. to do that when I'm handling the Mexican side of that. And sometimes there's people that they have issues such as a huge family with a number of spouses, right? Exes, call them that. So these people have considerable estate. And when there's issues in between the siblings because there are children from different mothers, it's not uncommon for them to have conflicts. And when it comes to state, there's some people that establish instructions in the U.S. wills that would be illegal in Mexico. In Mexico, the law says that whatever conditions you stipulate in a will that are negative, that are conditioning certain performances which are not ordinary, common, or legal, or honorable, they will be considered as not binding. So yeah, those wills could be applicable in Mexico, but they would have to be interpreted by a court or a notario to make sure that they don't contradict Mexican law.
So in the event that a Mexican spouse dies and the surviving spouse is a foreigner and there's no will, what are the claim rights? Can the family have claims to the assets, or full or partial over the spouses?
Let me see if I understood this right, because I did write one article a while ago about concubinage, concubines. That's something else. But if a person dies in Mexico and dies intestate, which is without a will, the family will have to get an attorney and file in court for intestate. It's not probate; it's intestate because there was no will, and then. It's a complicated, time-consuming process, and it's also expensive because of legal fees, because there are certain stages. One is to actually report to a court that someone died and left the state. And what the court has to do is to actually control the assets to make sure that they're not mishandled by someone without having a right to do that. Even if there's someone in possession, the state has to do what's right, and then the person who filed that report with the state doesn't have to be even a relative. I'm the neighbor. I noticed that my neighbor died, and I know that the property is vacant, so I'm just letting the judge know that this person died, so that they do whatever they have to do in order to put that into what they call that conservatorship or something like that. So to name a custodian by the state to make sure that the property is not taken for someone's advantage without having a right to it. But there's stages in which, okay, if I'm the spouse and the person died, here's my the death certificate, here's my marriage certificate, or here's my birth certificate on the son of the deceased, and then you go through stages until the family eventually is able to name a executor, which we call albacea, and then there's another stage where you have to appraise the state in order to determine its value and tend to determine if there's any debt incurred and there's a need to adjudicate property if there's no debt and it's transferable to the family, and it goes on and on and on. There's several stages or phases of it. How expensive it is, it could be rather expensive, from $8,500 on to potential thousands, particularly based on the wealth or the worth of the state itself.
Okay.
And again, as I was saying before, a concubine can claim rights to someone's state. So that is also worth discussing.
And actually, that was my next question to you. Is there common law marriage in Mexico?
Yeah, I actually have an article on that, and it specifies and cites the law, actually. But yeah, concubine has the right to claim rights to someone's state, even if she was not ever the spouse. But a concubine has legal rights in Mexico, and they go parallel to the wife. How do things get interpreted and who gets what? That's up to the judge. It's not my field. I'm not an expert on family law. But yeah, a concubine there or here will have the right to claim, or the children of out of wedlock can claim rights to that state too. So,
I heard that if a foreigner is married to a Mexican and the Mexican dies and they had assets, that the family, either the kids or the parents, can come and make a claim on a percentage of those assets for the Mexican that died. Is that true or not?
It has happened. Yes, I've seen that. Particularly those that are contested. I have cases in court here in Baja California where I have a trial attorney, more so a specialist in family law, in which a person that died in Mexico, a Mexican national with dual nationality, had married in the state, but he never actually divorced the spouse and married a Mexican in Mexico. Okay, and then. Yeah, people didn't know here because they're expecting you to be honorable and be single, right, in order to be married. So that marriage was legal, but eventually had a son, a daughter, born out of wedlock, of course. But now the children in the U.S. are filing for interstate in Mexico, and so is the widow, even though she was not legally the wife. Knowingly or unknowingly, I don't know, but there's a child that the deceased actually recognized and registered in Mexico as his daughter, and yeah, they all have rights to it. And what portion, the judge will determine who. And there's other complications because there's cases in which the spouse had received money from the now deceased to buy property. She registered the property under her name, but they were married in sociedad conjugal, which is community property, even if the name of the deceased doesn't appear. But since they never got a divorce, she cannot claim that to be hers because it's actually part of the state.
So is there community property? So if one person, if they're married and they're in Mexico and one of them dies, does the assets automatically transfer to the other one, or is it not? Does all of the assets for that marriage get automatically transferred if there's no will?
Well, there's a state, and even if there's a will, you have to go through probate regardless.
Okay. So
the difference is with the Fideicomiso, because the Fideicomiso skips that portion. That's why I keep saying, if I'm Mexican, and I am, and if I buy property, honest to God, I would create a Fideicomiso for my family. Why, Rafael, you're Mexican? Well, the fact of the Fideicomiso doesn't mean that the Fideicomiso was created just to give foreigners access to real estate. No, the Fideicomiso existed since the Romans, but eventually in this case, people just figure out Fideicomiso, property, codes, borders, banks. Well, no, it's not the case. A Fideicomiso will skip the probate, will save you a year in court, will save you $8,000 to $12,000 in the minimum, and within 90 days, you have the person naming the Fideicomiso being the rightful owner of the property with no more formalities or costs.
If they have multiple properties, would you put them all under one Fideicomiso, or would you have an individual Fideicomiso per property?
That's a good question, but I would say that particularly if the properties are adjoining, I would never place them in one single Fideicomiso. Why? There's this criteria by the government of Mexico, which is the department that issues the permits for Fideicomisos, that if you merge properties, right, into one Fideicomiso, if you later want to slice off a section of it, you cannot. You have to sell the whole Fideicomiso. So that's a problem because you wanted to get some money out of that, right? Probably it's just large in acreage or meters, but you wanted to sell that, you won't be able to do it unless you sell the whole property. And I've done that before for clients who don't understand why. Government is rather particular, so I keep saying, if it's going to cost you that much more to get another, to include in the Fideicomiso, just have another one done.
Right. Louis, look at the question.
I have another question. And this is actually like a two-part question because it applies for unmarried and married people. For the unmarried people, for the concubines, do they have to be registered with the government to be able to claim anything? And for the married people that are married outside of Mexico, say, for example, somebody married in the U.S., does their marriage need to be registered here in Mexico in order for them to claim it?
It would be convenient, and this somehow it's related. It seemed related to divorces. where people were married in the U.S., they have a home in Mexico, and they establish an address, a legal address in Mexico, in Baja California, and they've been here for over 2 years. And then there's, conflict, and then they fall out of love, and one wants to divorce the other, or they either consensual or not. They have to fight her, or they have to eventually agree that they have to register the marriage with the Registro Civil in Mexico in order for the court to recognize the validity and the existence of that bond, a legal bond named marriage. Yes.
I got a question regarding the Fideicomisos. Say that somebody here, they pass away. Is it the obligation of the bank to notify the family or the beneficiary that, hey, look at, that this person is now deceased in Mexico? So say somebody come here and it's an elderly man or woman, they are single, but they have family in the U.S. They named their family in the U.S. their son. They pass away, but nobody's been notified in the U.S. How would the family in the U.S. know to come and make a claim on that as a beneficiary?
Well, it's a bit complicated because usually family in the U.S. becomes aware of it by friends or relatives, because the bank doesn't keep vigilance. Sometimes the whole decade goes by without them being paid the fees, and they might find about something like the passing away of the client in the event that they had placed a lien and they wanted to take this to court and sell or auction off or adjudicate. It is not the case. Banks don't do that, actually. And people would say, well, they're so greedy. I know they're greedy. But I never been involved or known of a single case in which they actually filed to get their fees paid back. The problem, so it's that, okay, a neighbor finds out and then finds somehow who is the next of kin. They notify the next of kin. So the next of kin has to get to an attorney to do the investigations. Eventually, they may or may not be able to find paperwork at home if it's not been ransacked, particularly in those far away jurisdictions that they're just a plop or more than a plop in a rocky point somewhere, as I've seen, elsewhere. And they eventually have to find out, well, I know that my brother owned property. Can you find out about it? Yes, we go to the Public Register of Property and Commerce, and we run a search with the name of the individual. I know it's in a Fideicomiso, but the name will come up, right? So that is the first thing to do. Do a property search, find out was it ever registered, and then you have to find out was it current with Fideicomiso fees, was it current with property taxes, was occurring with federal concession, and then you start going step by step by step.
Is that a service you provide? Is that something you do?
I do, and it gets complicated. Sometimes people ask for help in other jurisdictions that I'm able to help, either by going there myself or hiring someone where I can monitor and control till we get results in order for me to intervene. But sometimes, it's just that people sell property under so many ways that I have a Fideicomiso. Well, they meant to have a Fideicomiso. They pay an attorney, but guess what? It never got transacted. There was never a bank involved. The guy had an accident, or he died, or he pocketed the money, and the people only have some emails with the attorney. But again, the question was, what if this person, the foreigner dies? The bank will not find out. They will find out that there's a procedure, there's a lawsuit, there's a claim, there's litigation, or there's a request of beneficiaries coming forward saying, I was named in the Fideicomiso, here's the proof of it, how I go about being named the rightful owner and take possession.
To continue with that question, though, I want to say we have received calls in the past of family members that know that their loved ones have passed away over here. They know that they have assets and specifically properties, but there's no way they're coming to Mexico. They're going, we know my father, my mother, my family, they have a property down there. They passed away, but we are not crossing the border. We're afraid of Mexico, or whatever reasons they can't get down here. Would they be able to call you, give you power of attorney? Would you be able to then start facilitating that process for them of selling the property and liquidating the assets?
Actually, I've been doing that for over a generation now. People call me from different states, different countries, actually, as I have clients from not just America. New Zealand, South Africa, you know. And the person only needs to give me power of attorney. Power of attorney could be granted before a foreign notary public, considered that the text, that the clauses are those that I provide in order to have them binding in Mexico, or the person may go to the nearest Mexican consulate or embassy and have the notario público, as it happens with the U.S. nationals away from the U.S. soil, and they give power of attorney there, which is actually per the instructions of the attorney, me, whomever, so that this person gives the power of attorney and is able to do all arrangements and file litigation, collection, or claims. That is something I provide to my clients. Yes.
Excellent.
I have another question. What if there's no beneficiary on the trust? What happens to the property? Or if there is a beneficiary and they are nowhere to be found, what happens?
Well, family member or spouse or concubine or child, even out of wedlock, can file a claim, and that would go to interstate.
Okay.
And I'm not sure if either you actually asked this or dream about it. Whatever happens with abandoned property, I guess there's a reason to discuss it at this point, because it's quite often an issue here along Baja California. I remember going to Lancaster with one of my brothers, and we were driving past a community, real nice community, and my sister-in-law was texting something, and she texted the address, and she got all the information right there and then. I don't know what website she went into, and she found everything, even the property wasn't on the market. But that's not something you can do here.
Yeah, I know.
People, I saw this in Punta Banda, I saw this elsewhere. If you don't know the seller, if you don't see the paperwork provided by the seller, if we don't have a way to be in touch and discuss the legal transfer, acquisition of property, you cannot go to the state and file a claim or buy from the state. It doesn't happen as in the U.S. It's one of those dark areas of laws in Mexico, which shows how backward we are in so many things. This is one of them, and it's mesmerizing how the state doesn't even get the advantage of claiming that and making it its own for as many uses for public services, right? I know that's how I feel about it, but Mexico hasn't legislated in that sense. So it's like trying. I've been asked to do it, and I keep telling them, "Are you sure you want to do that? I don't feel good about making money this way, because guess what? You probably have like a 90% chance of not getting anything back, right. And I don't want to feel odd about it by leaving that for last." So that's what it is.
Okay. Louis, are there any important questions we have left?
There's one, but I'm not sure if you know, Rafael. What if an American dies here in Mexico and the Mexican spouse needs to claim assets in the U.S. but does not have a visa? Do you know what the process for that is?
That's a good question, and in this case, it would be the opposite case of when you asked when Kanoa asked me if I could do that for others, which are northbound, right? It's the same thing on the opposite end. They hire an attorney. The attorney will tell them to go to the Mexican U.S. consulate actually and grant power of attorney under the instructions of the family law attorney or probate attorney, in order that power of attorney is allowing him to engage and render the services, do whatever searches, findings, and filings.
Excellent.
I want to say I really appreciate your time. I know we've been on here. This is it's been a long call, but we're gonna probably break this up and share pieces of it. If people want to watch the whole video, they can. But we're gonna take the pieces out and we're gonna share them with our Facebook community and our followers. And we're also going to put your contact information below, because once again, we want people to be able to contact you and hopefully give you business. You put so much effort into educating the public online in your Facebook group, and I highly recommend people, if they haven't, been there to join the Facebook group and read the information and educate yourself, because not only do you need to find the right professionals, but we all have to take responsibility. And the more educated you are with what your rights are, the better you'll be able to choose the right person to represent you. And because we all want to have people to have safe and secure transactions, because we got to live together. We're going to be neighbors. We're going to be, we're going to be having dinner, and we're going to be having fun down here in Rosarito Beach. And the better that your transaction is, the more fun everyone's going to be having once you move down here.
Thank you for watching our video. If you're planning on buying real estate in the Rosarito Beach area, make sure to give us a call. Have a great day, everybody.